Good afternoon. If we sorted this out, you should all be able to hear me, and in a second you'll be able to see me once we get past this title slide. Today we're going to be talking about getting creative with global settlements, lien waivers, litigation costs, and clever consent agreements. Hello everyone, there I am, donned in some Lois merch today as opposed to the usual suit and tie. As usual, this is a live question and answer, so if you have any questions, feel free to post them in the GoToWebinar viewer, and we'll take a peek at them at the end. So all questions welcome. All right, so let's talk about the global settlement as a concept. So occasionally the workers' comp case and the third-party case will be in a position to resolve simultaneously. And in order to limit our exposure and reduce the fresh money payable to the claimant, what do I mean by fresh money? Well, if we fund a global settlement with a lien waiver, we actually don't pay anything presently. Fresh money refers to the concept that above and beyond what we've paid in comp already, there are additional payments made to the claimant, money moving in other words. So in order to limit our exposure and reduce the fresh money payable to the claimant, we can consider a full or partial lien waiver to fund all or part of settlement of the workers' comp case. Even if the workers' comp case is an active litigation, reduced benefits due to a third-party settlement credit and offset is still powerful motivation to settle. So I just wanted to point that out in advance because I know a lot of times this dialogue goes, you know, is the workers' comp case at permanency? Has our adversary made it to band? You know, is it sort of languishing at the moment? And all of that stuff, you know, even if surgery is potentially on the table, and that's the issue we're litigating, you know, if the third party action is about to settle and you can get on the horn with the adversary and say, your client's going to net $500,000 from $1 million settlement, your client's never going to see more than a third of payments going forward. You know, that $900 total disability is now $300 per week. He could try and subsist on that, or alternatively, he could take a lump sum up front. It's pretty powerful motivation. So just something to keep in mind. All right, so just a word on the requirement for our written consent. Section 29.5, this is in New York only. We will talk about New Jersey in this webinar. It requires our written approval. The burden is on the claimant to get the carrier's consent and to prove that valid consent was obtained. The failure to get our consent before settling results in a waiver of future workers' comp benefits. It's as good as a free Section 32. It's better than fraud under Section 114A, even because that's just indemnity. This gets you indemnity and medical. We did have a case disallowed that had about $300,000 in remaining exposure over a failure to reimburse $16,000, and they did ultimately reimburse it. They just did it 6 months later than what was specified in the consent, and that was good enough. So something to file away. The claimant has some remedies under Section 29.5 if the carrier will not or did not give consent, but just note that it's either or. There seems to be this conception that they have to ask for our consent, and then if we say no or if we don't respond, then they can move for a compromise order. That's not the case. They don't need to contact us at all. They can just go ahead and file the motion, and as long as we're noticed on it, we have a chance to interpose an opposition. As long as it has everything required under the statute, and we are going to talk about that in a little bit, that's good enough. You don't need to ask for our consent first. So a brief word on Section 40 up front, and we're going to touch on it a little bit more as we go throughout here, but I know everyone's mostly here for the New York content. So Section 40 does not have a consent requirement. However, you should always draft a letter anyway, and this letter memorializes all of the terms of the settlement, the numbers breakdown, reservation of rights, all of that other stuff. So we always recommend setting it forth in a formal writing. We do send it via certified mail to prove that it was sent. Why do we do this? Well, many attorneys automatically take off 1/3 and $750 off of your reimbursement in New Jersey. That is not how it works legally. That is how it is going to play out most of the time. But there are some notable exceptions. So the reduction to your lien in New Jersey is capped at 1/3. It is not an automatic 1/3. When does this become important? Settlements over $750,000 the attorney's fee starts to get limited by the court rules. So if you're looking at, you know, a $1.5 million settlement in New Jersey, chances are the attorney's fee is not 1/3. And in recent years, what the appellate division has been doing with that is just figuring out what the total attorney's fee is divided by the total settlement, in other words, an average. And that's the percentage that ends up coming off the lien. That is also the percentage future benefits are paid at. They're not paid at 1/3, they're paid at whatever that percentage is. Obviously, in most cases, costs and disbursements are going to far exceed, New Jersey calls them expenses of suit, they're going to far exceed $750. One of these years, the legislature is going to amend that and at minimum probably double it. But for the time being, $750, pretty much every civil case that's, for something other than like a $25,000 minimum policy that's tendered immediately, you're probably going to go right over $750. However, if it's one of those situations I talked about where the adverse carrier gets on the horn and goes, this isn't worth my time, liability is strong on your end, here's the policy. Well, the only thing that comes off the lien is the actual litigation costs, not $750 automatically. So we did have a situation where the actual litigation costs were about only $150. So the guy took off $600 off of our lien rightfully. We were able to actually get that $600 on a credit against the eventual permanency award. So, it wasn't earth-shattering money here, but it's important to keep these guys honest and make sure the law is applied properly. So it's not automatic. We always ask for a proposed closing statement. We ask for itemized costs and disbursements. We want to make sure it's all legit and it's all on the up and up. So often disputes arise as to future credit and offset rights. You can try and negotiate paying at a 1/3 rate weekly on a permanency award. Owens versus C&R Waste Materials says you're technically supposed to pay 1/3 up front, but you can agree to try and pay it out weekly if your adversary will go for it. Most will not. It's always a good idea to get that in the letter memorializing the settlement anyway. And the written memorialization avoids any confusion, and it gives you something to point to if there's a reopener. So bear in mind, if you accelerate, and I'll mention this in a little bit, if you accelerate the payments under Owens versus C&R Waste, you might pay 1/3 of the OAS up front and then never pay anything else. And you're going to forget, if you're not making weekly payments, that the petitioner has 2 years from the date the last payment is made to file for a reopener. Under the law, that's 2 years from the date the last payment would have been made. So you might pay a lump sum of a few grand up front, then pay nothing, and then 4 years down the road, you suddenly, get served with a reopener. Chances are it might actually be timely. So it's always a good idea to lay out, the time frame for the reopener and all that other stuff in a nice little letter in New Jersey, even though it's not required. And also, if somebody just sends you a check for, your lien minus 1/3 minus $750, which happens more often than you would think, don't cash it without verifying the costs and disbursements and the attorney's fee, please. It's just, they do this all the time and it drives me batty. So, just from a moral standpoint, just send it back to them. Anyway, I'll get off my soapbox so we can move forward here. All right, so Section 29.5 consent ground rules, and this is, we're laying sort of the groundwork here for what the global settlement is. So this is just a contract. That's all it is. The 29.5 consent agreement, consent letter, consent to settle, whatever you hear it called. All it is a settlement contract. It is not a board form. We don't have the board's, sigil on it. It's referred to colloquially as a letter. You'll hear consent letter a lot. In my opinion, it is best practices for it to be an agreement. In other words, there's a signature for me to countersign on behalf of the carrier, and I want third-party counsel and the claimant to sign off on it, and I want the claimant's signature notarized. Why? Because if any of these issues are ever litigated in front of the board, I want to be able to point to that and say, his attorney signed it and he signed it. This was explained to him before he signed it. This argument that they don't know what's happening to them right now is complete nonsense. So in my opinion, I am not just going to serve a letter on our letterhead that says we hereby consent. I want them to sign it and send it back, and then I'll countersign. Get a proposed closing statement, or at minimum, an itemized breakdown from third-party counsel. Sometimes they'll tell you the closing statement is privileged or confidential. Depending on the amount of the settlement and the amount of your lien, it might not be worth the fight. If they'll just give you a breakdown in an email, as long as you have something in writing, that's good enough. But I do want itemization of those costs, particularly once they start getting into the thousands of dollars. It's not totally out of the realm of possibility if they have a bunch of expert fees, but again, sometimes they'll ding you for some stuff that really shouldn't be your responsibility. The biggest one being settlement funding loans, JG Wentworth 877 cash now kind of stuff. They'll get paid up front for their settlement. They'll have to reimburse it once the case actually resolves, and they'll take $5,000, for the settlement advance as part of the costs on the closing statement. You can't avoid Section 29 by moving around when the money is paid. That's not legitimate. So that's why we ask for an itemized breakdown of the costs at minimum. You're always going to hammer out the terms in advance. It is not recommended to just send a letter that unilaterally says what you want. That's a recipe for wasting everyone's time, and they'll just send it back to you. I'd rather get on the horn with the attorney and say, this is where we stand. Is that good to go? Okay, great. I'll send this over. Please sign it. And always remember that you are holding all the cards. So what do I mean by when I say you are holding all the cards? Bear in mind that their remedy, if you do not consent to the settlement, is a compromise order under Section 29.5. Otherwise, they have waived the right to workers' comp benefits on behalf of their client. So they need your consent or they need the compromise order. The compromise order is a pain in the butt, especially if you've litigated a case for 3 or 4 years and you're inches away from a finish line and a $100,000 attorney's fee. You've already agreed to the settlement amount with the defendants, you're ready to go and you're ready to sign the releases. Now the comp carrier says, no, I'm not consenting. The stuff that's listed in 29.5 that you actually need, an affidavit from the physician, the nature and extent and period of the claimant's disability, an affidavit from the attorney of no conflict in the settlement. All of the different components of a Section 29.5 compromise order are laid out in the statute, and there's actually more requirements if you seek it 3 months later. That's called nunc-pro-tunc. So they need your consent. It is a pain in the butt to go with the alternative. It's okay to stand your ground. Don't fall for the bullying, and we'll get into that in a few minutes as well. So I put this up here, this slide, while I was going on a bit in case any of you wanted to get started, but I did my best to break down what our consent letters contain in terms of individual components. State what this is at the outset. This is our consent pursuant to Section 29.5 of the Workers' Compensation Law. No dispute as to what the document is. State what your lien is. As of such and such date, we have paid a total of X, comprised of Y in indemnity and Z in medical. Non-admission of liability. Nothing contained herein is to be construed as an admission of liability for the payment of workers' compensation benefits. This is applicable in denied cases primarily because they do still need your consent, even if it's a denied case. So you can say where applicable, the carrier continues to raise and maintain all issues of controversy. An integration, or you might hear this called as a merger or entire agreement clause. This agreement represents the final consideration of the parties and may not be contradicted by any prior statements, whether oral, written, or otherwise, cannot be modified without signatures of both parties. In other words, I don't want to get this written consent that everyone signs off on, and then our adversary says at a hearing, and they've tried to pull this stuff before, oh wait, I thought we agreed orally that you were going to take it as a credit and not reimbursement. Well, that's not what it says in the letter, is it? So I do recommend having that in there. Third-party settlement breakdown, the gross amount is this, you said your costs are this, your attorney's fee is this, the net to the claimant before we get reimbursed is this, our reimbursement is this, then the net to the claimant is this. So I break down all of the math. You would also calculate the cost of litigation percentage, we'll get to that in a second. Discuss interplay with the no-fault carve-out in MVA cases. If you've seen any of the webinars or dealt with an MVA case, you'll know we have that $50,000 carve-out we got to work around. I'm going to talk about that in a few minutes, but you definitely want to break that down in the consent letter, and I'll talk about why. Calculation of the cost of litigation percentage. Your attorney's fee is X, your costs are Y, combined they are Z, divided by the gross settlement equals, a percentage. Terms of the global settlement, if applicable, carrier has agreed to waive a percentage of its lien in exchange for the claimant's agreement to proceed with a full and final Section 32 settlement. The settlement proceeds shall become payable upon approval of the Section 32 by the board, et cetera, et cetera. Express reservation of credit and offset rights, and explicit statement of how they will be applied and when. I can't stress this enough. If you just reserve rights per burns, and then you say, oh, and we have dollar for dollar offset rights, those are two inconsistent statements. You're going to end up paying at the burns rate. I would always specify what the credit amount is, which is the claimant's net after we get reimbursed, after fees, after costs, and I would specify how benefits are going to be payable going forward and at what percentage. Explicit payment instructions. You have to send us a check within 15 days of your receipt of the proceeds from the defendant's carrier. You should issue it to the below address, referencing claim number, whatever. Contingent revocation if terms are not complied with. Yes, we have seen board panel decisions where you can get away with this, and it will result in a 29.5 violation. You say something at the conclusion of the letter to the something that resembles, This consent is expressly contingent upon adherence to all of the terms and conditions set forth herein. Claimant understands that a failure to adhere to any of these conditions shall constitute a violation of 29.5, such that claimant will have waived the right to future benefits. We even specified this includes the conditions as to timeliness of the settlement payment, provision of a final closing statement, etc. Consideration of Medicare's interest, this is if applicable, but if there's a big old third-party settlement and you're worried about a potential Medicare issue down the road, I do like to say that third-party counsel has considered Medicare's interests and satisfied them if required, and that the claimant agrees to hold us harmless for any issue that arises with Medicare down the road. Why am I putting this in there? Because ultimately the whole point of Section 29 is to foist off liability for payment of comp onto the party that's actually responsible. So if Medicare comes down the road, later on chasing after me for reimbursement of comp benefits that they think we should have paid, I want to be able to point to the claimant and say, you got to reimburse me for this. Requirement for a final closing statement. In New York, there is a specific form that is filed with the Office of Court Administration after everything is dead, done, and dusted. I want that form. I want a proposed closing statement so I can draft the consent, with knowledge and a pretty accurate, reflection of the settlement numbers. But I want to see the final closing statement to make sure a defendant didn't chip in another $5,000 or your costs were off. Finally, signature and notarization. We sort of talked about that already. I'll go through this very quickly. I kind of touched on it. The importance of getting the consent right. Any ambiguities are going to be construed in favor of the claimant. If you fail to expressly reserve your future credit and offset rights, you have waived them. Sometimes you pay more than your fair share under Burns because the consent does not specify. Bear in mind that all that Burns requires is that you contribute your equitable share of the claimant's litigation costs. If you have contributed more than the claimant's actual litigation costs, you have satisfied your Burns obligation. When does that situation arise? When your lien actually exceeds the third-party settlement. Because if you think about it practically, if you have a $100,000 lien and there's a $50,000 third-party settlement, if you lop off 1/3 of your lien, your reimbursement is $66,666. You've reduced the lien by $33,333. On a $50,000 settlement, his attorney's fee is not $33,000. The reduction to your reimbursement is already more than what his actual attorney's fees and costs are. In that case, Burns rights would be dollar for dollar. And that makes sense because if the claimant is going to get any net settlement such that we would have credit and offset rights, in that situation, we'd actually have to waive part of our reimbursement for money to move to the claimant. Otherwise, we're entitled to the entire settlement. So don't pay more than your fair share under Burns. It's possible you have to make Burns payments when you consent, but then down the road, you actually reach the threshold. You are never required to pay more or contribute more to the claimant's litigation costs than their actual litigation costs. Navigate rights in an MVA case, what is or is not paid in lieu of first-party benefits. We have a bunch of different webinars on that particular topic, but first-party benefits has a definition under the law. Indemnity up to $2,000 per month for not more than 3 years, necessary medical treatment and expenses up to $25 per day. So if you're under $50,000 that you've paid on the case, and there were periods where you paid more than $2,000 per month, you're entitled to reimbursement of about 2/3 of what you paid beyond $2,000 per month in indemnity. This only matters if you have yet to pay over $50K, because once you pay over $50K, you've satisfied the threshold, and we're no longer concerned about calculating what amounts were not paid in lieu of first-party benefits. Finally, you must be clear about any waiver of rights. If you're going to say the claimant waives Burns such that the carrier has a dollar-for-dollar credit going forward, that has to absolutely be specified. Same with any lien waiver to fund a global settlement. All right, the thing that makes it all possible, Williams versus Lloyd Gunther Elevator Service. So this is a third department decision from 2014. Basically, it says you can apply your credit and offset rights when specified in the consent agreement. Usually this means you're going to apply it as of the date you consent. What the law used to be is that your credit would take effect once the claimant received the net third-party settlement proceeds. This allows you to issue your consent and quote-unquote freeze the lien, and it avoids changing your reimbursement amount and the Burns rate and the Burns payments. You can issue your consent, freeze the lien, and then the numbers aren't changing and the goalpost isn't moving. while the global settlement is pending. Note that you can actually halt benefits without a Section 32. The board's jurisdiction is limited to interpreting the terms of a third-party settlement consent agreement. This is even with a directive to continue payments by the board. Even if you are under a CCP, you can consent to a third-party settlement, take dollar-for-dollar offset rights, and suspend benefit payments while a Section 32 is pending on a global settlement. It avoids the consideration changing. It is totally legal. Anything else results in a double recovery to the claimant. That exact issue has been litigated a bunch of times. So what's marvelous about this particular case is it is the one situation outside of a Section 32 where you can actually unilaterally suspend benefits. All right, we've had plenty of webinars on this topic, so I'm just going to touch on it briefly. So we got to navigate the no-fault carve-out and MVA cases. Big consideration here, does loss transfer apply? Is any vehicle over 6,500 pounds, or is it a livery vehicle? If it is, and somebody's asking for your consent to settle, I'd consider holding off on consenting because currently you have some leverage, don't you? You know, every carrier on earth is looking to close the books on the case, pay the settlement, and ride off into the sunset. Well, they can't have the claimant sign the release without you consenting first, or without the claimant getting a compromise order. So that's the moment to serve an intercompany reimbursement notification and go, gee, adverse carrier, I would really love to consent so that you can close the books on this case, but we got to figure out what we're doing with this first 50K. You'd be surprised how much leverage that actually is. You can resolve the loss transfer claim without going to arbitration. You can get paid all at once. That's why I'm including it in this webinar. It is sort of a global settlement on its own front. So I would consider holding up your consent to the third-party settlement if you have an outstanding loss transfer claim, or if you think you should serve one. Also, consider including in the Section 32 addendum, the addendum to the waiver agreement, the written portion that we include, that the carrier is seeking loss transfer on the proceeds of the Section 32. If the carrier cannot recover the Section 32 via loss transfer, the claimant agrees it is not a payment in lieu of first-party benefits. So this is in there because the issue of whether a Section 32 is paid in lieu of first-party benefits is still unsettled law. So what I basically say is I'm going to try and get this back from the adverse carrier via loss transfer. If that doesn't work, you agree to reimburse me about 2/3 of it. This avoids any issue with it when they settle their third-party action. It's just a best practices kind of thing. Again, this only matters if you have not paid over 50K yet. If the lien is under $50,000, I would double check whether all benefits were in lieu of first-party benefits. We talked about that, indemnity paid over $2,000 per month or more than 3 years after the date of loss. There are some other exceptions, an out-of-state accident, for instance, or the defendant's not being a covered person under the statute, for instance, a defendant motor vehicle driver. So there are some exceptions. Make sure the carve-out actually applies. The understanding in New York is that a motor vehicle was involved, therefore you don't have a lien until you pay 50K, and that is just legally incorrect. All right, addressing Kelly, Burns, and Bissell are cases in New York. So Kelly gives you the calculation for the reimbursement amount and future offset percentage. I'm going to show you a breakdown of what this looks like towards the end. Burns addresses our future offset rights. Absent an agreement to the contrary, future medical and indemnity are payable at the Burns rate, typically about 1/3. Bissell was a hybrid of Kelly and Burns. It says future medical is speculative, so it's paid at the Burns rate. That does mean that if medical treatment comes in while your credit is running, you can object to it via CA.1B on the basis of the credit. The consent is a contractual agreement. We talked about this, so lay everything out. How is the cost of litigation percentage calculated? Based upon what numbers? How do future offset rights apply? When do they start? What are the claimant's obligations? For instance, with that medical treatment I just talked about, we like to say it is the claimant's responsibility to ensure that the providers are paid for medical treatment in accordance with the New York State Workers' Compensation fee schedules, and the claimant must submit compliant claims for reimbursement pursuant to Burns and Bissell thereafter, including the treatment records, proof of payment, and the invoices, after which, if the treatment is otherwise compensable, the carrier will reimburse the claimant the Burns rate of the fee schedule. I like to have that in there so that there's no questions about our rights as to medical treatment. How is the future offset calculated? What is the net to the claimant? How do we protect ourselves if any of the settlement figures change? We talked about that concept of contingent revocation. How is ongoing medical treatment addressed? What about a CCP? We talked about all those issues on the previous slides. Also going to sort of gloss over this one because we talked about possible waiver of Burns rights. So we only pay our share of litigation costs moving forward, and it applies absent an agreement to the contrary. You can get around it in a consent. Specify exactly when our Burns obligation will be satisfied is one way. Claimant agrees to waive all future Burns rights. They usually will not do this without consideration. A present lien waiver to satisfy Burns. So if you see that you have to pay another $10,000 before you equal the claimant's actual litigation costs, you can waive $10,000 of your lien so that dollar for dollar offset rights are applicable going forward. No matter how Burns rights are negotiated, it should be spelled out explicitly in the consent. The claimant agreeing for dollar offset rights and both parties reserving Burns rights will result in the board applying the Burns rate. An expert tip on this front: if the settlement is small and you are asked to compromise the lien, you can try to negotiate a Burns waiver in exchange. The claimant is going to say, I'm not going to sign the release if I don't see a dime, and you go, okay, well, if I have to waive any portion of my reimbursement such that you receive money from this third-party settlement, I want my offset rights to be dollar for dollar. You know, it's really going to net out at zero for the claimant ultimately, but at least they get a lump sum up front. All right, now we got the background stuff out of the way. So let's talk about the global and some creative stuff we can do. So typically, but not always, a case is going to be postured for a global settlement when the workers' comp and civil claim are in the latter stages of litigation. The workers' comp case does not need to be in the advanced stages. The credit and offset rights are powerful leverage at any stage of litigation. We talked about that, like even if there's the question of authorization of surgery on the horizon, unless the claimant is really insistent on getting that surgery and it's not just to beef up the value of the case, which it very frequently is, saying that you're going to have to pay for that treatment out of pocket, then you can submit a claim, and if it's otherwise compensable, like it's consistent with the MTGs, I'll reimburse you the Burns rate of that treatment, but only the fee schedule, the Burns rate of the fee schedule. Or, that total disability you're getting at $900 per week is now $300 per week. Good luck. So anytime you have a third-party settlement first, while the workers' comp case is ongoing, there is an opportunity to posture for a global just by leveraging your credit and offset rights. But if both cases are nearing sort of the end of their lifespan, that is a prime opportunity for a global. Potential triggers on the workers' comp case to keep an eye out for: permavals, LWEC trial, adversary has made a demand, or you've given authority because counsel has made a recommendation for a 32, or the case is just languishing, claimant's not actively prosecuting it, you'd like to get rid of it for nuisance value. Potential triggers on a civil case: the big one, a note of issue is filed. That signifies readiness of the case for trial. That's usually, you've heard the expression settling on the courthouse steps. That's usually when negotiations get serious. They're usually not going to pick up in seriousness until after depositions, EBTs they call them otherwise. So another trigger is EBTs are completed, or mediation or arbitration are scheduled, or there's a settlement conference on the docket. You may not know about mediation or arbitration unless a notice was filed with the court or by the court, but settlement conferences are viewable in the online docket. So what's a $0 32? When the estimated exposure on the workers' comp case is equal to or under the lien reimbursement amount, we can fund the Section 32 with a full or partial lien waiver. Colloquially, you will hear this referred to as a $0 32. Do not call it that in the agreement. That is a fast track for a confused law judge to say this settlement is not worth anything, there's no consideration for it, I'm denying it. It is not a $0 32. We specify that no money is moving to the claimant. However, the consideration for the settlement is the lien waiver. Remember, the award has to be paid within 10 days of the notice of approval. And if you're funding a Section 32 with a lien waiver, you are not in control of issuance of that payment, right? You're waiving part of the lien. That's going to be payable from the third-party settlement. You don't have that money. Third-party counsel does. So if you have to issue the award within 10 days, you want to make sure that you're covering yourself on that front. So we specify in the consent, it includes a hold harmless clause. The claimant agrees to hold the carrier harmless for any late payment penalty under Section 32. You cannot say that in the Section 32 agreement itself. One of the trigger words that the board looks for in rejecting the agreement outright is hold harmless, but feel free to put it in the consent. Claimant will hold us harmless for any late payment. We're not in control of when third-party counsel cuts the check. Be sure to factor in the size of the credit when evaluating workers' comp exposure. If we have a large enough third-party settlement credit under Burns, indemnity medical is worth 1/3 of what the adversary thinks it's worth. Or if we have dollar-for-dollar offset rights, the workers' comp claim is worth nothing for as long as the credit runs. That is important to factor into your valuation. And again, we're going to look at a practical example of how this works. One of my favorites, because I believe a couple attorneys in our office in the past year have prevailed on this exact issue. You can make your consent in a global contingent upon the 32 approval. And you can say, if the claimant withdraws or if the 32 is not approved for any reason, the carrier's consent is revoked and this shall constitute a violation of 29.5. You have just strongly incentivized not backing out of the Section 32. Because if they do, you're getting a free 32. So I would always include that in the language. Is there an equivalent in New Jersey? Yes and no, are everyone's favorite answer in the legal field. So Section 40 does not apply to Section 20 settlements, and Section 40 credit is not a basis for a Section 20. What do I mean by that? You need actual contested issues, liability, jurisdiction, causal relationship, dependency, those little boxes you check off on the Section 20 order. However, utilizing your credit and leverage to negotiate a Section 20 or if other contested issues exist is still viable. That calculus works the same way it does in New York. We have a credit, we have an estimate of what future benefits are worth. Guess what? They're worth 1/3 of what you think they're worth. Therefore, the Section 20 is worth 1/3 of our estimated exposure. Additionally, for Section 22 order approving settlement, Owens versus CNR Waste Material requires acceleration of our share of litigation costs. This 1/3 upfront responsibility can be satisfied with a fuller partial lien waiver, which would mean paying $0 on the OAS. So that's the functional equivalent of a $0.32, yes. Note that the petitioner retains reopener rights from the date the last payment would have been due under the OAS. We talked about that. You're going to forecast out when under the PPD award the last payment would have been made. 2 years from that date is when they have reopener rights until. That's from Anderchak versus El Moral Bake Shop for anyone who's curious. Note under the appellate division decision in Cali versus Hitachi Power Tools, the petitioner can agree contractually as part of a Section 20 dismissal order to reimburse it under Section 40. If you are going to do this, and this is a settlement agreement that basically settles around how the law works, this should be on the record, as in the settlement affidavit, or testified to that the petitioner understands it at a hearing, and on the Section 20 order itself. But yes, you can reserve Section 40 reimbursement rights on a Section 20. All right, you've probably heard this before. If you haven't heard it before, you've been a victim of it. What about my attorney's fee? So our adversary wants to get paid, right? But there's a $0.32. They don't get a fee unless fresh money is moving on the workers' compensation case. In New York, attorney's fees are a lien on indemnity payable to the claimant. So if we're not paying any money and no money is moving, there's no fee. So this isn't really an issue if the same office is handling the workers' comp and the civil case. That's your best case scenario. They'll work it out on their own end. All the money's going to the same kitty ultimately. But otherwise, you're going to hear this quite often, even if they don't say it aloud. They will come up with nonsensical objections as to why the 32 is quote unquote unfair. It's not unfair to their client, it's unfair to them. So there are some ways around this. So claimant attorneys will oppose a $0 Section 32 sometimes without valid rationale because they do not get a fee unless fresh money moves. So here are the ways we can sort of navigate around this. Option 1, have third-party counsel negotiate sharing the fee from the third-party settlement. Yes, this is a thing. Bear in mind that the attorney's fee is usually only about 15% of the Section 32. So even on a $100,000 Section 32, which is pretty high, you're only talking about 15 grand. So if there's $1 million third-party settlement and it'll grease the wheels and allow this thing to go forward, you'd be surprised how often the third-party attorney is willing to go, sure, just give them 15K for mine, whatever. Option 2, pay fresh money for the Section 32. This one is really quite clever. There's a lot of moving parts, but I promise you all you're doing is shifting money from point A to point B. You are still netting out at $0. So pay fresh money for the Section 32 up front, like $100,000. So money is actually moving. So you're actually cutting a check once the notice of approval comes out, right? But the consent agreement also specifies that you're going to get reimbursed the amount of the Section 32 from the third-party settlement proceeds once the 32 is approved by the board. So the way this works practically is you cut a check for $100,000. Our adversary gets a $15,000 fee on it. The claimant keeps that money, right? It's in their pocket. We've sent a check. The board approves the settlement. That's why we just issued the check. And then third-party counsel was holding $100,000 in escrow. They then now cut you an extra $100,000 on top of whatever your reimbursement amount is going to be, so that you ultimately end up paying out $0 on the case. You've paid the money up front, the claimant had to reimburse it. Ultimately, you haven't paid anything extra. All you did was shift around the payments from point A to point B. Yes, that is viable. It's not shenanigans. It's legal, I promise you. Option 3, the nuclear option. I mean, ultimately, the decision's up to the claimant. If you don't want to take the settlement offer to them, I'll get on the horn with the third-party attorney and say, listen, I'd really love to consent to your settlement, but we got a stick in the mud over there on the workers' comp side. You want to just take over the comp case for your client, tell them what the deal is? I don't like doing that. It's nasty, but that's why I referred to it as the nuclear option. That's if all other options fail, break glass in case of emergency kind of thing. All right, let's go through a practical example so that we can get our hands on all this stuff I've been rambling about. So, say the estimated workers' comp exposure on the case is $300,000. Maybe there's $100,000 in medical. We're estimating $200K in indemnity. Our current lien is $200,000. The third-party settlement is $1 million, plenty of money to go around. The attorney's fee is $333,000. Costs and disbursements are $7,000. So the first thing we're going to do is figure out our cost of litigation percentage. I made the numbers nice and easy. It seldom ever works out this way. We usually go to 2 percentage points. But for the purposes of this example, $340,000, that's 333 plus 7, over $1 million is 34%. So what are we currently entitled to get reimbursed when we're going to consent to this third-party settlement? Well, we lopped 34% off $200K. $132,000 is our maximum current reimbursement. So what's the claimant's net going to be? What's the amount available for credit and offset rights? $1 million minus the $340 in litigation costs, minus our $132,000 reimbursement is $528,000. This is the amount of our credit. So because the claimant's net, $528,000, exceeds our estimated exposure of $300,000, remember we said that's what we're forecasting, that's what our reserves are, and that's what we're ballparking the case is ultimately going to be worth. We can assume that $300,000 is actually only worth 34% of that, or $102,000. Why? Because the moment we consent, benefits are going to be payable at the Burns rate of 34%, and that goes for medical and indemnity. This case is not worth $300,000 anymore, it's worth $100,000. If the adversary demands a fee, we talked about this sort of clever example, we can agree to a Section 32 of $102,000, 34% of $300K, and pay it out of pocket. But then we'll specify in the consent that $102,000 will be held in escrow and becomes payable to the carrier after the 32 is approved. So how does it work practically? We get back our $30,000 immediately upon consent, and then after the Section 32 is approved, another check for $102,000 comes through the door. We are out $102,000 for a span of 2 to 3 months, but then it comes back in. They've gotten their attorney's fee. We've still netted out at $0 on the 32. We've just greased the wheels so that the case can move forward so that our adversary gets their fee. All right, last little tidbit before I'll give you some practical takeaways here. Other consent issues. So if you find yourself in a construction case, maybe you're a GC or an owner, or there's an OSIP, I want you to be very careful with this particular issue. Or say a judge directs you, the workers' comp carrier, to appear at a mediation or arbitration because the lien is a sticking point. Consent can be implied if the workers' comp carrier is the same as the third-party liability carrier, or if the carrier participates in settlement negotiations and agrees to the settlement. So if you go into court for a mediation or arbitration, and you say on the record, yeah, $33,000 reimbursement is good with me, I'll consent to $100K third-party settlement. You just lost the right to do a written consent under 29.5. That is going to be implied consent. It depends on the facts, depends on board findings, but be very careful if you're appearing for a mediation or arbitration to reserve formal consent rights. How does that work? There's usually a mediation order or arbitration order if the parties are able to reach an agreement.
and just throw a stipulation in there. This consent is contingent upon the carrier providing formal written consent under Section 29.5. The carrier reserves all rights pursuant to Section 29 to be memorialized in a subsequent formal writing under 29.5. Anything of that nature, just to cover your butt. Courts have previously held that oral consent can be found based on the facts. Be careful what you say on the phone. But recent decisions made clear that formal written consent is almost always required. The requirement to get consent under 29.5 includes voluntary abandonment or discontinuance of a third-party action. We just had a case where a claimant filed and discontinued the third-party action all in the span of 2 weeks, very close to the third-party statute of limitations. They thought we wouldn't know about it. We caught it. We raised 29.5. And a case that was going to languish otherwise for another 3 years. There were myriad issues in this case and possible future surgery and reduced earnings and all kinds of, we were nowhere near permanency, at least a year away from permanency. A case that was otherwise going to languish, well, now she's staring down the barrel of $0, period. So that one ultimately settled for 45, which I thought was actually a very reasonable resolution, all from raising the specter of a 29.5 violation. So do those docket searches, people, it's worth it. 29.5 gives them an either or. We talked about that. They don't need to ask for your consent first. And the last thing I'll point out is there are specific requirements for a compromise order. Those are usually pretty easy to oppose, those particular petitions, because they very rarely fail to include, or very rarely do include, all of the itemized things that Section 29.5 says they need. Those oppositions kind of write themselves. There's an additional showing required if it's sought nunc pro tunc. What does that mean? Latin, it's now for then. If they seek approval of the settlement more than 3 months after it was agreed to, it's considered nunc pro tunc. On top of everything Section 29.5 lists, they also have to show that the delay was not prejudicial to the carrier, that the settlement is reasonable, etc. So there are some heightened showings if it's sought as an NPT motion. You might hear these referred to as cram down motions. All right. Let me give you some practical takeaways before we wrap up here. Your written consent is required. Use it. Remember that you have leverage because your consent is required, and if they don't get it, it's a waiver of future benefits. And their only other option is to file for an NPT motion or a compromise order. You are holding all the cards, and we talked about that in the loss transfer context. If you don't have an answer on whether you're getting back that first 50K, gee, adverse carrier, I'd really love to consent to the settlement so you could close the books, but you haven't responded. So consider holding up that settlement until you get an answer on the loss transfer front. Just a side note, because I can't help myself, Insurance Law 5105C actually says that loss transfer claims do not impact the bodily injury policy limits and vice versa. So if they say to you, my policy limit is $100,000, that's what I'm paying on the third-party settlement, I have no further liability, that's actually legally incorrect. The $50,000 is not coming from their bodily injury coverage. It is coming from their mandatory prescribed policy endorsement under regulation number 68 of $50,000. We pay $50,000 in lieu of comp. They have to have $50,000 in no fault available for their insured. Loss transfer is exactly what it sounds like. The $50K we paid in comp, we pick it up and we move it over to their $50K endorsement. It has nothing to do with bodily injury policy limits, so don't fall for that. Continually assess whether the claim is postured for global settlement. It's easier if the same attorneys handle workers' comp defense and subrogation aspects. Is that something of a shameless plug for our own method of handling cases? Sure, but I do genuinely mean it. It is much easier. Consent is just a settlement contract. You can agree to whatever you want, move around the attorney's fee, include revocation clauses, etc. Watch out for the issue of implied consent. We just talked about that. Make sure the exposure analysis of the workers' comp claim is factoring in the third-party settlement credit. If you are valuing it at $300,000 and you have a $500K credit, you are valuing it incorrectly. It is worth $100,000. Navigate the no-fault carve-out. A stipulation in a Section 32 about the loss transfer. Check whether all benefits were in lieu of first-party benefits. If you've paid under 50K, make sure the carve-out actually applies, etc. We talked about those issues. And finally, do not take their word for it on anything. I'm just saying that as a general statement. Remember I said we always ask for the before and after closing statements. We'll also tell you a third is not a thing. That's their insisted settlement breakdown. That is not required under the law. If they don't like it, they can seek approval from the civil court. Guess what? The law actually says the civil court is required to award you the reimbursement you're entitled to under the statute. In neither New York nor New Jersey are you going to be able to vacate or quash the lien. So you will take what we agree to. A third is not a thing. If you're not okay with doing that, and if your client's not going to sign off on it, great, let me know in writing, because then I'll just subrogate and settle for the amount of my lien. I'm sure the defendants will be happy to pay me less than what they're paying you. That's what Section 29.2 and Section 40F exist for. Proof of fees and costs, we talked about the before and after closing statements. Viability of the case, raise your hand if you've heard them say, liability is not strong, there's an issue with my expert report, claimant's not going to testify well, this thing's going to get dismissed on summary judgment, blah, blah, blah. They'll give you every excuse on earth why their case is absolute garbage, and therefore you should waive a portion of your lien. Don't fall for it. You can do your own individual liability assessment, but I guarantee you 90% of the time it's just puffery and posturing, so don't take their word for any of it, please. All right, with that, let's get to the questions and answers. I know I've been going on for quite a bit, so I appreciate you guys hanging in there. Let me pop this thing out. Oh, wow, I must have done a great job. I don't see any questions. All right, thanks as always, everyone, for tuning in. I hope this was helpful. Feel free to reach out to me individually if you have any questions on global settlements. Hope to see everyone next month. Thanks again.